If you need to protect yourself from your future partner, who you have to lay in bed with every night, the potential mother or father of your children, you shouldn't be marrying them. I would love to think in an ideal world that was true. But I've been in this business a long time, and prenups really work, and they help people out a lot. It's just like when we get a will, we don't want to die tomorrow. We're not hoping we die or planning to die. We are planning for the contingency that we know is a possibility. Well, it's 100% possibility in the event of an estate plan. Hey, everybody. Welcome to the I Just Want This Done podcast. I'm Rayford Palmer, your host, and we've got a fully loaded show today. We are a little disjointed on a live stream, don't worry, but on the recorded show, it will appear seamless because we are broadcast professionals. Off and running here, we've got a fully loaded show today. Rahul, tell us about Dak Prescott. First, for the people playing the home game, you need to explain a little bit about who Dak Prescott is and tell us the scoop on this situation.
Yeah, so Dak Prescott, for those who don't know or don't follow the NFL, is the quarterback on the cusp of MVP discussions every year, always has great statistical seasons. Dak Prescott was engaged and soon to be married, very soon to be married to Jane Ramos. And
that engagement's been going on for a while, right?
Right. Just recently, maybe a few weeks ago, the two of them called off their wedding.
But yeah, warning. The wedding is called off. Alert to, if any of you were guests, you don't have to go now. So
two daughters, Margaret and Aurora. There was no argument or blow up. It was a mutual decision. But as we know, it's not always mutual. And so there's been now speculation that it had something to do with a prenup, although Sarah Jane Ramos, the ex-fiancée, says, it had nothing to do with the prenup and it's just a rumor and it has no basis. They were just supposed to get married very shortly in Italy, according to this article from Us Magazine.
Destination wedding, red alert.
10-carat diamond ring, another alert.
Oh,
there.
Another one, giant rock.
Yeah.
By the way, I'm engaged. It says October 2024. By the way, we're citing Us Magazine here online.
Correct.
But the best line here was Ramos said on Instagram, "This has nothing to do with the prenup. I hope we can put that rumor to rest now." Well, okay, what is it?
But why'd you get disengaged?
You went to the bachelorette party. You got all this stuff set up. You're engaged a year and a half. You have kids with this guy. What's the deal?
So it's either the prenup or it's some sort of infidelity that might have come out or occurred or what have you, without speculating. So
apparently there was a podcast that she saw, some podcast called Speakeasy, clearly not as popular as this show.
Of course not.
But Ramos was watching, and a host said that they were anti-prenup. By the way, we want prenup. We are not anti-prenup on the I Just Want This Done divorce podcast. The host speculated about what could have led to the split, and this guy said Emmanuel Acho.
Yep.
Rhymes with nacho. I'm sure he's never heard that before. Emmanuel Nacho, rhymes with Acho, said in the discussion, "I believe if you need a contingency plan for marriage, you shouldn't be marrying them." Okay, dude, you go ahead and fly without a seatbelt. No parachute. Be my guest. This is Emmanuel speaking. If you need to protect yourself from your future partner, who you have to lay in bed with every night, the potential mother or father of your children, you shouldn't be marrying them. I would love to think in an ideal world that was true. But I've been in this business a long time, and prenups really work, and they help people out a lot. It's just like when we get a will, we don't want to die tomorrow. We're not hoping we die or planning to die. We are planning for the contingency that we know is a possibility. Well, it's 100% possibility in the event of an estate plan. But you're not looking forward to it. You're not anticipating it. You're just being smart to prepare yourself for that. It's the same thing with a divorce.
That, and also it's instead of thinking about it as a prenup, which is like this thing on a pedestal or whatever the case might be, this taboo topic, you got to think about it. You got to reframe it in your head as if, look, the state of, fill in the blank, California, Illinois, Minnesota, whatever, they have a set of rules as to what happens in the event of a divorce. That is already there. What a prenup does is just rewrite those rules for how it applies to you. So it's not like you're creating this a document that's going to really, really set the stage for what happens to the extent that, that already exists. You're just tweaking it as to how it should apply to you. We say, we don't want what Illinois law has to do for us. Instead, we agree to doing it this way instead. And so prenup does not equal bad. It just means you're smart about thinking about what to do.
I was talking to a potential client yesterday about a prenup, and she was really cool. It was a good conversation. And she's just being very kind of open about the idea. I think younger people are more open to the idea. I can say we've seen a much increased interest in prenups. We would do 1 or 2 a year 10 years ago, 15 years ago. We do more like 1 or 2 a month, maybe more than that now, of either reviewing or drafting. They're way more common than I remember. The stigma has really changed. People just aren't surprised that somebody's asking for one. But one of the things I was talking about with this person was it drives a really important value conversation. Like you said, it doesn't need to be this big deal. And if you do the conversation early enough, preferably right after you get engaged and like a year before the wedding, you're not going to run into all kinds of grief and have this hard conversation 2 months or 1 month before the wedding, which is not when you should be talking about it. Yeah, you want to talk about this stuff way in advance because it generates a very important values conversation. What about kids? What are we, when, how many? Are we having kids at all? By the way, if they say they don't want kids, listen. We've actually had cases where somebody didn't listen and then they thought, oh, they'll change their mind. That's a huge value item. And if they're in their 20s and they don't say they want kids, they probably are pretty sure they don't want kids. Anyway, I digress.
Like Rafe was saying, you have prenups and you have these value adds, and ultimately the two of you really need to just align on what's important for us and make sure that if that value isn't aligning, you should really just have a more serious, or you should really have a serious conversation about where is this going to go, because you don't want to be in a position where you've now paid for the venue, you can't get the money back, you've paid for caterers, you've sent out the invites, you've got family all flying in, friends and family flying in from all around the state, the country, the world, and weeks before or months before or a month before you have this conversation, and either someone feels pressured into signing something, creating a lot of distasteful, conversation leading up to what should otherwise be a very happy wedding event, or it breaks it off, and then you end up losing a lot of money and a lot of hard feelings and all that. So that's why it's really, really important. And like Rafe was saying, don't expect someone to change their mind on certain things, etc. So we don't really know what happened, obviously, in Dak Prescott and his situation. In the ideal world, like Emmanuel Acho said, you shouldn't need any of these things because you'll live happily ever after. But in the real world, in reality, that might not always be the case. So we have that. Now, similarly, in the athlete sort of scope or space, Luka Dončić and his ex-fiancée, the news spread that they separated and then she took their kids back to Slovenia, where Luka is from. So he, and then according to this basketballnetwork.net article, he hired Laura Wasser, as everybody, as we previously talked about in other episodes, the high-profile divorce attorney who represents celebrities in California and probably other states as well. So according to this, it sounds like Luka Dončić, who, by the way, for those who don't know, just like with Dak Prescott, Luka Dončić is a world-famous, incredibly talented basketball player who plays for the Los Angeles Lakers. He started playing basketball in the European League when he was 16, was drafted by the Dallas Mavericks, about 5-6 years ago at this point, and was then recently traded to the Los Angeles Lakers maybe a year and a half ago. And so he was engaged. He has got, I think, 2 children with his fiancée, and she left and then filed a petition for child support and attorney's fees in Los Angeles court. Luka had said that he had called off his engagement to Anna Maria, is her name, after she returned to Slovenia with her firstborn, Gabriella, and then remained there after she gave birth to their second daughter, Olivia, last December. So 2 kids. She moved back to Slovenia. He went back to visit their daughter, then came back to play in the NBA. And while the mother, Anna Maria, remained in Slovenia. So according to this article, he hired Laura Wasser, who then filed a motion to dismiss the petition for support, arguing that neither Luka Dončić or Anna Maria nor their 2 daughters are residents of California, and that he had filed a family law action in Slovenia last month to address the issue, and the party's home country was the appropriate jurisdiction. So essentially what she's saying is that Luka plays basketball in California, but he's not a resident of California in the jurisdictional sense of the word. The kids live in Slovenia. Ex-fiance resides in Slovenia with the children. And therefore, the case should happen in Slovenia where everybody is. Why are we doing it in California? Why are we doing it in LA? Except because, and then she argues that she is trying to take advantage, she meaning Anna Maria, the ex-fiance, is trying to take advantage of the generous child support laws in California and preventing her client from seeing their children. So that was the argument, it sounds like, in addition to the jurisdictional situation. So they are now trying to get the case. It was filed in California. They're trying to get it dismissed and then sent back to be handled in Slovenia, where everybody resides. It remains to be seen what will happen here. It was very, very unexpected because I do recall seeing a lot of chatter in the sports world about people who couldn't believe that this is going on with Luka. Otherwise, it seemed like a very nice relationship that they had, at least during their times in Dallas, etc. So that's now happening. And so we'll keep you abreast with how that turns out. And with that, we will now go to the third celeb news story for this episode. This is regarding people we'd previously discussed in prior episodes. Kandi Burruss and her, obviously, husband at the time, Todd Tucker. So, as you know, she is a Real Housewives star, I would say. I think you can call them stars. TV show, Real Housewives of Atlanta power couple. So in this BET.com article, that describes this, the two of them were married in 2014 and then called it quits in 2025. And then TMZ just reported, as this article suggests, that after months and months of courtroom drama, the two of them agreed to a no alimony, meaning no one is going to pay any spousal support one to the other, and a joint custody deal that, quote unquote, looks fairly civil with no child or spousal support for either side. Kandi Burruss will give Todd Tucker, a $426,000 lump sum to balance the scales, as they call it, and the two will split credit card points down the middle and plan to sell off a shared food truck. So essentially what it sounds like is they are equalizing, in their own world, what we call in Illinois, the marital estate. Kandi has her assets and liabilities. He's got his assets and liabilities. And so as to equalize those two columns, she will be giving him $426,000, which when added to his column should, I guess, according to this anyway, equalize how much the two of them will net after all this. We don't know what that number looks like. We just know what the lump sum is. They'll deal with credit card points separately, and I'm sure they have a lot of those, and sell their food truck, which I'm sure they'll probably split the proceeds 50-50. They also have two kids, a 10-year-old and a 6-year-old, and they'll both have joint legal and physical, what they call guardianship. So it sounds like they'll have 50-50 custody or decision-making. She, meaning Kandi Burruss, will hold on to the passports, but he can request them for trips abroad. So this is a very common policy. Because you only have one set of passports, one party has to actually hold them. This does not give that person any advantage or the other person any disadvantage, but rather it just really is a possessory interest. So in this case, they're holding the passport, and anytime there's a trip, anytime there's one thing or the other, that will be exchanged, and then returning from the trip, they will hand the passport back. And so that's what they're doing there. And then they have a car collection. Kandi Burruss is keeping her 2022 Bentley SUV, Cadillac Escalade, Ford F-250, Porsche Cayenne, and the 1963 Chevy Camaro. He's taking the 2020 G-Wagon, the 2020 911 Porsche, 2023 Range Rover, the 73 Bronco, the 63 Lincoln, and the Ford Transit van. They also split real estate and things like that. So it's a nice, clean break, and a lot of people should probably take some notes. So that's what's going on there.
Sorry about my absence. Thank you.
No, absolutely. So we just went through the stories here. So we kind of went through the rest of it. So we just finished talking about Kandi Burruss. We had also previously talked about Luka, and then we finished talking about Dak. So welcome back.
Thank you. So apologize. I had to deal with somebody coming to the office here. So, okay, let's, we're going to do some listener questions. Can you ask me this first one? I'll be happy to get into this one.
So we have an Illinois Support Network, a Facebook group where people can ask questions, and it's a nice supportive community there, which is also There's also a moderator, so that way nothing inappropriate, untoward happens in there.
We moderate the group, 1,600 members and growing every day. Free to join, anonymous to post, and people in the group comment and help each other out. And then we moderate to make sure it's a safe place. And we answer questions. And so sometimes we answer them on the show, and sometimes we answer them in writing on the group in the group. So we try to really help people out.
Yeah, absolutely. So here's the first question. My spouse was fiscally irresponsible during the course of the 16-year marriage. For example, they were cashing out 401ks. They were being underemployed. They accumulated a lot of debt that was unknown to me. I have consistently saved for retirement and paid off any known family debt. Is it possible? If so, how can I protect myself during the divorce given the circumstances?
Okay, there's a lot here. So first I'll say without a prenup, so let's assume there's no prenup because they don't mention one. A prenup could govern this situation potentially. Here's the problem. The problem is you're in for a penny, in for a pound in a marriage. And the short story is if you are married to a spender, somebody who wastes money, is a gambler, they are not under earning, whatever, and you're not happy with that. Really, realistically, if you don't have a prenup that covers this issue, assets and income and liabilities, you have really two avenues. One is a postnuptial agreement that might help you sort out some of this stuff and decide to stay married using a postnuptial agreement that determines how you'll deal with your current assets, liabilities, income, and expenses, and provides some protection about what's going to happen if you get divorced. But for most people, your only remedy is getting divorced. And the problem is, if you choose to stay married to this person, you're voting yes for this kind of treatment. This comes up a lot where people will say, I didn't sign up for this. I shouldn't have to give them half of my assets. I was a careful saver. They wasted the money. There's no their money and your money. The court sees it as one pot. The marriage is one unified entity, like a business. It's a 50-50 partnership, whether somebody contributed 10%, 0%, or 50%, the court sees it as an equal partnership. So the problem is if you're the saver and they're the waster of money, they've got nothing or they have debt, you get the privilege of splitting their debt and then sharing your assets with them too. It's a double whammy. So your only option is get it under control and get them to behave themselves, or get a divorce. And this is also true for things like infidelity or any bad behavior. Really, your remedy is getting divorced. And if you choose to stay married, and you may have a million good reasons, the court doesn't care why you stayed married. The court just cares that you're still married. And so you could have a halo on and say, well, I tolerated this behavior forever. And you're effectively going to get punished for that because you voted yes on continuing to deal with that situation or agreeing for it to continue. People will say, well, what about dissipation of assets? What about waste of marital assets? Dissipation of marital assets is a thing, but the problem is it is spending for a non-marital purpose after the marriage has undergone an irretrievable breakdown. And there's a time limitation on that. You can't go back and look at 15 years of history and say, I get paid back for half of that. You don't get to go back and look at everything and pick everything apart. We have arguments about when the marriage underwent an irretrievable breakdown. The latest date, of course, is the date a divorce case is filed. And remember, we are not a community property state where that date of separation really is important, because at that date, you no longer accrue community property, or what we would call marital property. We don't have that in our state. There's only 8 community property states. So you're stuck with the other person all the way through the day you get divorced financially. So the word to the wise is, if you've got a problem, get it under control or get divorced. Those are really your only options. I mean, you could consider a postnup. Those are rarely used and they have limitations in terms of what they can do. They can't, you're not going to, well, I'm not going to generalize, but consult with an attorney for details. But postnups have very limited use.
And they need to agree to it.
You're right. What's more, they need to agree to it. And they might say, hey, go take a hike, because you've agreed with this behavior for 10 years. Why are they going to agree to a postnup now? They'll say, well, divorce me. Well, maybe you're going to have to. So this is a real problem. I feel for this person, but you don't get a prize for being like the better person financially.
Which is unfortunate, but it's the way the law is.
Yeah. And also the flip side of this is the big wage earner. Let's say there's no waste of assets, but one person's a stay-at-home parent, the other person's earning all the money. And they say, well, this isn't fair. I've earned all this money over the 30 years and they get to take half of it. And so we're not here to tell you good, bad, and different. Get a prenup if you don't like that. But there was a lot to this question. I wanted to answer this in some detail. When I saw this, I thought it was great for our show because this kind of regret thing is common. And we just sit here saying, geez, there's nothing you're going to be able to do. You don't get points for this. Anyway, I hate to tell them it's a bummer, but there's no protecting yourself. The only thing you can do is once you can file a petition for a temporary restraining order preventing future bad spending during the divorce. But, you're largely damaged. At this point, the damage has been incurred. Anyway, I'll hit you with this is a 3-parter. This is like a really big education in retirement accounts, ladies and gentlemen. So strap in. This is going to be interesting. Number 1, as part of my divorce, I was awarded a Roth IRA, individual retirement account. The judge ordered this account to be handed over to me and not part of the other account that requires a QDRO, QDRO, Qualified Domestic Relations Order. That is a court order that allows a 401k or pension to be split with no tax consequences. It creates effectively a rollover of, let's say, half of the account to the other spouse. So this person is saying there was a QDRO that divided, let's assume it's a 401k. Then there's this separate Roth IRA, and I was ordered to get the whole thing. In these divorces, we try to keep them as simple as possible. A lot of times, if somebody has some smaller accounts, we say, you keep those, you keep your smaller accounts. We're going to divide the big one to balance. So they're going to get the Roth IRA. They say, I signed and had to get notarized a form for opposing counsel, the other attorney, and sent it back to his office in February. I've not heard anything back at all. I'm not wrong to think this is a usual amount of time to transfer the account that's not part of the QDRO, right? So that's part 1.
So let me answer that one real quick before we jump in. So for this one, it's all about, setting expectations. What is actually happening? I think it's not knowing what is currently happening is what the question is. It's hard to say if this is usual or unusual. And it's more about, since you sent it back in February, I'm not sure if you sent it back, you had to get it notarized. So I'm guessing you probably mailed back the original or emailed a notarized version. I'm not sure. Let's say you mailed or dropped off a hard copy back in February. Depending on when the question was, we're now, towards the end of March here. So
before you get into this, can you quickly outline the steps here? Like you got to set up your receiving account, or if you're keeping your own, that's easy. But this sounds like they were awarded a Roth from the other spouse, so they need a place to hold it, right? And then if you can explain the steps about like step 1, get this, step 2, so that, and then talk about timing.
Please. Yeah, absolutely. So step 0. The divorce judgment says you get this Roth IRA, right? So that's the starting point. So what do you do here?
I think a lot of people see that and they're like, I'm good, right? I get it.
But physically, how do you get the money? You need a receptacle for it, right? As they say. So what do you do? If you have a financial planner, great. Speak to them first to see how to go about this. If you don't have one, I'd encourage you get one. But you contact one of these brokerage type of places, like you call a Vanguard or you call a Fidelity or Chuck Schwab. I mean, you call Edward Jones. You call one of these people, by people I mean one of these institutions, and you open an account like you would a bank account. But you would say it's for purposes of, quote unquote, rolling over a Roth IRA from your soon-to-be ex-spouse. So when you physically go to this branch to set this up, you'll want to make sure you have your divorce paperwork with you. There, you'll say, look here, my ex-husband or ex-wife, my ex-spouse had this account that I'm supposed to be awarded. Now, we're going to be working on getting some of these rollover documents signed over, but I need somewhere for this money to physically go because the signed documents basically direct, let's say, your spouse's account administrator to send the money to you. So they're going to say, well, where do you want us to send it to?
If you have a Roth IRA already, it's likely you can just have the funds transferred to it. You're good to go. But if you don't have one, you're setting up an account for the money to land in.
And so because these are IRAs, you want to make sure that it's done properly because you don't want to, for example, open up just a regular checking account and put it in because you might get some unintended tax consequences. I don't know that's going to happen with a Roth, but you might get some penalties. It's best to sort of talk to someone about this, about exactly what you should do. But suffice to say, you need to have a destination account for this money to go to. So then you open up that account. Then you fill out this letter of direction or some other transfer form that these institutions have, pre-printed forms that you'll have to populate with account numbers, destination, name of accounts, etc. And then it sounds like that's what you filled out and dropped it off, had it notarized and dropped off. So now you said it was opposing counsel's office. So they probably are working with their client who actually holds the account to give that to them, to give to their institution so they can create and then transfer this account or the contents of this, the value of this account to you in accordance with your judgment.
And that goes to what we call the plan administrator, which let's say they have their Roth at Chase. They go to Chase, they send this thing to Chase. And then what goes on from there?
And what goes on from there is Chase will probably, when they get any sort of a legal document, they'll have their legal team review it. They will make sure that everything is in accordance with what Chase has its sort of guidelines of what all it needs. So they want the form and they want the court order. Then legal at Chase they have an entire team, I'm sure, because of how big this bank is, to review these kinds of documents. So legal will go ahead and make sure everything is appropriate and then do the actual transfer itself. So now, how long is this process going to take? I don't know. It can take a couple of weeks. It could take a month. But what you should do is you should follow up. Just send an email to the attorney and say, hey, I dropped this off or I sent this to you on so-and-so date. Is this complete? ? Can you please give me an update? ? Something like that. Or have your attorney direct it to them if you have an attorney.
Yeah, and your ex may know what's going on too. So if you're talking to them, you could text them and say, hey, you know what's going on with this form? I sent it to the lawyer. Where's this stand? They probably know what's happening too. But it can take several weeks for this stuff to be processed. That's not unusual. So if it was February, this person didn't say it was beginning of February or at the end of February, it might be utterly normal. The lawyer might have turned around quickly and you could wait 8 weeks or something for this to get processed. It just takes time. These IRA rollovers or transfers, quadros, they take time to process.
Right, exactly. So it could very well be normal, but you're 100% correct that you should be in the loop about what's going on. So a quick question doesn't hurt. Just don't pester them and do those things, or be accusatory, things like that. Just ask them a question.
Yeah, it's perfectly fine to follow up and say, hey, what's going on? And get an idea, ask them what the expected timeline is, and then check in with them when it's getting near that period of time. So, okay, next I want to ask you another, this is a short, kind of easy one. And then we'll follow up with a little more detailed one. Can your soon-to-be ex come after your 401k? This is a relevant question. Can your soon-to-be ex come after your 401k if the marriage was short? Would the judge allow it? Kind of an interesting question because it really goes to any assets. Like, hey, if I had a short marriage, what is the other spouse entitled to?
Well, the law gives them an entitlement to their equitable share of what the law considers to be quote-unquote marital property. So if your marriage is short, and short could be, in some people's minds, a 5-year marriage is short. In other people, compared to a 25-year marriage. In other people's minds, a 1-year marriage is short, 5 years is long. So it really just depends on what a short marriage is. But the answer is yes. The court has to follow the law. They can't decide with, pick and choose what they want to do. So to ask, what will happen? Will a judge make me divide or make them split the 401k? Yeah, they will. If it goes to a trial, the judge legally has to, unless you have on the other side a 401k of approximately equal value, which the court can say you can each keep whatever. And by the way, when we talk about 401ks and values, it's important to know, the whole thing might not be marital. It's just the marital portion.
Could you explain what the marital portion is specifically?
Yeah. So it's any money that you put in to your 401k or any other retirement account, or just any asset generally, from the date of marriage until the date of entry of judgment for dissolution of marriage. So that chunk, those bookends, create the marital estate. So
it might not be a lot. If you haven't been married a long time, we may be talking about not a ton of money, right?
Exactly. But it will still, the court has to split it. So if you don't want to split it, it is in your best interest to work out a deal outside of having a judge make the decision. So you'll want to propose a settlement agreement where, you might each keep what you have respectively and do some sort of an offset or whatever. But if it goes to a judge, the judge has to follow the law.
Right. If the marriage is very short, like months, it may be that your soon-to-be ex is okay with what we call a walkaway, which is just everybody keeps their own stuff because it's just easier and it's close enough. But like Rahul said, technically, you're going to split the marital portion equally. And a short marriage doesn't just magically mean you get out of the rules. Like, oh, well, since I was married a short time, I I don't have to split my assets. Well, yeah, you got to split the marital assets. And this is where a prenup comes in, because if you're worried about getting divorced after a short time, that's what a prenup is for. People married 30 years don't feel as bad. I mean, maybe they feel bad about a divorce for its own reasons, but I would generalize and say, if somebody's married 25, 30 years, they figure, we got a good run. I'm okay with it. And splitting the stuff, probably fair enough. And it's not good, but okay, it's okay. We raised some kids. We had some good times. We're splitting this money, getting support, whatever. The prenup is really for people's fears of, aside from trying to preserve like a big non-marital asset, like the family inheritance or a family business. And that family says, hey, you need a prenup to keep this away from your spouse. What everybody's really worrying about is the short marriage. They were married 3-4 years. It doesn't work out. And there's a divorce. And then there's all this mess related to this divorce. And everybody likes the idea of the prenup to protect that. If you're married a really long time, there are people like, I'm not so worried about the prenup at that point. But yeah, that's your remedy. And it's similar to this other one where the person said, I saved all this money and they didn't. Well, there's your protection is a prenup or, get divorced. So Rahul, got another part to this. This is the tray, as they say in basketball. Can we talk about a quadro and if the divorcing spouse can drag it out? I'm guessing that means the work related to a qualified domestic relations order. Also, what if they are the plan administrator themselves, plot twist, for the 401k, and they rolled money into an IRA, because they dissolved the company and the 401k? Worried if it's an IRA, it's more vulnerable and they might withdraw money during or post-divorce. They are an attorney themselves. Please help. So just for a brief footnote of part of my question, so the audience understands, if you have a small business, you can create your own 401k in your small business, but you're subject to the rules of big companies. And you have to fund the 401k with the correct amount of money. When people say I'm withholding, you got to make sure the withholding cash actually gets in the account. And companies get in big trouble if they basically steal that money. So they have to keep that account funded with the money that the employees put in it. Then they also have to put the matching money in and all that stuff. And when a company's dissolved, what this person says happened, it sounds like they pulled the money out and put it in an IRA. I'm guessing it's a personal IRA. They're not clear on that. So Rahul, can you address, can the quadro process itself be delayed or fooled around with? Number one, is there something more vulnerable or risky with an IRA when they were the plan administrator of the 401k? Something that you address on that?
Yeah. So a lot of this requires, absolutely, if you don't have an attorney, make sure you get an attorney, because there needs to be a lot of discovery, as they call it, go into this. You need to request statements showing both, how much is in there as well as the deposits. And you need to compare that to what they stated was being put in there to ensure that there is nothing untoward happening with the money. So you want to make sure you do all that discovery. If you do find something untoward happening, before you get to the quadro stage of doing all these things, you can only enter a quadro after the judgment, usually after the judgment for dissolution is entered. By that time, you're already divorced. So if there is money missing, things like that, you might have a dissipation claim that you'll have to address in the underlying case. So if there's less money than there's supposed to be, while you can't make money materialize, you might have to get a larger share of a different asset to make up for the money that's quote unquote missing. So all these things should really be done before you actually get divorced. And then so that way everybody knows what's there at the time of the divorce. Now, once the divorce is done, if he moves out, let's say the judgment says you get 50% of the account, and then after the judgment is entered, he pulls 50% of it. So you only end up getting 25% of what's left because he took the other 50%. At that point, you will have recourse by coming back to court and ordering him to, repay that to you, sanctions, etc. Now, can you delay the quadro process? I mean, theoretically, you can, but again, that's why you have a judge who will oversee this. Should someone file a motion, go before it, a judge to really say, look, I've sent this to the plan administrator, which happens to be him. He's just not approving it. I need to send this to the ultimate bank. Now, he might be a plan administrator.
Usually not. Usually they have what we call a TPA. They have a third-party administrator doing the actual work.
I was going to say there should be someone who actually works at the plan itself where the money is being held. at the institution, in the institutional level. So I would just, leapfrog him or her and then go to that person directly. So that's what I say. But make sure, if there's this level of complexity, you do need to get a lawyer to make sure they can walk you through all this.
That's great. Thank you. So that's a lot of stuff about 401k retirement accounts, but we thought all this stuff was worthwhile. I don't know that we've really discussed much about this in past shows, so we wanted to cover it. So what's this next one? You can hit me with this.
So Rafe, this person says, I've been divorced for a year and we have a child together. I'm in the process of buying a house, but my ex-husband is being unreasonable and is not agreeing to the move that I have ready. I need to file a petition to relocate and also let him know 60 days prior to the move. Does anyone know how long this takes? I mean, if I close in 30 days, that doesn't give me enough time to go to court, etc. Anyone have any insight on this? Really, what it sounds like is they've been divorced. They're co-parenting this child. She lives relatively close to him. She's now moving what we call more than 25 miles away, which is what triggers the relocation statute in Illinois. So you can move under 25 miles away without really... You don't want to move 24 and a half miles away because it's going to create a problem. But I mean, generally speaking, if you move 10 miles away, nothing really changes. But you move over 25 miles, then you need to seek permission from the court or his agreement or her agreement, the other parent's agreement before you can move, because that will affect the parenting time that this person will be able to have with the child, because this distance is, especially in Illinois, very, very vast. So that's what the structure is. So typically, what would you say to this, Rafe? What would you answer here?
With respect to this, we don't know if it's a sole custody or joint custody situation. I guess I'll assume it's joint custody, or what we call shared allocation of parental responsibility, or joint allocation, where they both share in the decision-making for the child. This person's putting the cart before the horse, or the house before the child. And it's backwards. So relocation is a big deal in Illinois, and it's not easy to get. So if your ex is not agreeing to relocation, you've got a fight on your hands. So to give you a little bit of history, relocation used to be called removal, and it was related to the state lines. It all had to do with taking the child out of state. And this is actually as recent as about 10 years ago, the law changed. But what was interesting was the relocation or removal cases would come up when somebody wanted to move across the border into Indiana or Wisconsin. If they want to move to California, that's one thing. But the edge cases literally became a family that lived in Lake County, and mom wanted to move right over the border, right into Wisconsin, literally maybe 10 miles from the previous home, but just over the border in Wisconsin. And you'd have to go through World War III litigation to do it if the person didn't agree. And similar with Northwest Indiana, if somebody living close to the Indiana-Illinois border, somebody want to move just a little bit, not to New York State or Florida, and you'd have the same fight on your hands as if they were moving out of state, basically. So they thought, that's not right. Let's create a mileage restriction rather than a state lines restriction. And the other irony was, as I used to tell clients, the funny thing about our law is, let's say somebody's living in Lake County. You can't move to right over the border in Wisconsin, but you can move to Cairo, Illinois, which is 8 hours south. That was okay. And there was nothing parents could do about it, believe it or not. So a group of divorce lawyers knew this was problematic and proposed a lot of changes to Illinois divorce law. So divorce lawyers aren't all bad, folks. There's a group of smart lawyers that put together revisions to the Illinois state divorce laws, and a lot of them were put into effect in a package in 2015 and then amended over the next couple of years to clean up some other issues. And one of the improvements was this relocation law. So now it's relocation. Now it's 25 or 50 miles, 25 if you live in Cook or the collar counties, 50 miles if you're outside of the collar counties. The idea being you're in a rural area, so 50 miles is a more logical distance. We're really talking about car rides for children, right? Here's the pickle here. This person decides they want to move, just says, yeah, they start making the situation, put it together. They're going to close on a house and then realize, oh, I have to get my ex's permission to move because I'm outside of 25 miles, we're assuming. And I'm guessing they don't expect the spouse, the ex will agree. Well, I got news for this person. And I wrote in a post in the Facebook page, I said, you need to put off this closing. If you don't get an agreement from your spouse, this litigation could take 9 months. It could take more than a year in Cook County. There's nothing easy about relocation litigation. It is essentially a custody battle all over again. If you're relocating, you're typically radically changing the parenting schedule, because if you are outside of 25 miles, that's an hour drive or more. Like in the Chicagoland area, it can be 25 miles in the metro. Go from the north side to the south side on a busy day.
Mm-hmm.
Go from the Loop to Cook County, suburban Cook County on a busy day. It'd take you an hour.
Well, not to mention now you have other issues like you're changing the child's school district. You're now, so if there's a thing where one parent has to drop the child off at school, now you've unilaterally decided that this person has to drive 25 miles further than they would otherwise. So now their work schedule, if they had it all balanced out, figured out, now has to be radically changed again. So,
and really you get into this interesting place where if it's an hour, it might as well be a 4-hour airplane ride. I'm exaggerating just for effect, because if you've ever had family that used to live around the corner, 2 blocks over in the same town, and they move an hour away, you don't see them every couple days. When they live down the street, you saw them every week. When they move an hour away, it's like, we can only go there on the weekends. It's a long drive. People are busy lives. So now parenting time changes radically. And instead of 2-2-3, whatever schedule you've got some often, handoffs back and forth pretty frequently. Now you're talking about, well, what are we going to do? Week on, week off. We have some major changes to parenting schedule potentially. And they could be huge changes because this person might be moving 2 hours away. We don't know. So there's a lot going on here that we don't know. But the bottom line is, this is real big time litigation. And you're going to be fighting, depending on how unhappy your ex is about this. You could be in as much of a battle on this as you were in your original divorce case. And you'll spend maybe as much as you did in your divorce case. I've been in a couple major relocation cases. One went to trial. Well, a couple that I can think of that took months and lots of money. And one of them we won, and a woman relocated to Washington State. That had some unique facts. The other one, the child was able to relocate out of state also for another set of unique facts. And I'm not going to disclose that, but they were bitterly fought cases. And both parents thought they were right. So buckle up for months or more of litigation and spending many thousands of dollars on this. The bottom line is, you should have talked to your soon-to-be ex or your ex first, seen if they would be willing to agree, because they just sign a form and then you file it with the court and you're done. It's easy. So yeah, it's a tough deal. So, okay. Moving on, tell us about Tinder. We always like our dating app stories. What's the scoop on Tinder's? What are they doing?
This article just came out, but essentially says, as the title reads, is that Tinder is now requires facial scans for new UK users. So basically, starting in October of last year, 2025, although the article was just published now, it says that Tinder is requiring users to scan their face to optimize and to enhance safety and security. Because I guess there's been a lot of scammers and fake posts, this, that, and the other. And so this is another way to verify the identity of the people making these accounts, etc. It's another safety measure, whatever. But, this creates another question of how is this going to make people nervous about giving their biometric data now to the match group, right?
Haven't people just surrendered privacy already anyway?
It's all gone. So now this company is going to have to store your facial characteristics and features in enough detail where it essentially scans you. So it's going to essentially have a database of all people who've been using Tinder. And if that gets into the wrong hands, you never know. So again, they're trying to solve a problem for dating. They're asking for more security, but which comes with a downside also in security, because if there is a leak or someone hacks into it and stuff, and your biometrics are now out there, something to think about. So
the dating apps have been suffering. That's stuff we've been talking about. They've been dealing with declining user usage and what they call churn in the software business, people leaving the apps. So they want to keep you on there. And they've introduced some AI features, of course, because that's the du jour thing, is we got to add AI to this. So I was looking at this when I looked at your article too. They've got Chemistry, which is an AI-powered matchmaker being tested, rolled out in US and Canada about 2 weeks ago. The quote from them is, "It's Tinder's AI-powered way of cutting through dating fatigue." Okay. Chemistry will use Q&A and scan your camera roll, a little creepy, to get a better sense of who you are. So sanitize those camera rolls before you let Tinder check it out. In return, Tinder users get a daily curated match recommendation. Oh, okay. AI helping us. This reminds me of the matchmaker thing we filled out using a mainframe computer. I'm old enough to know what a mainframe is. Back in 1986 or 87 in high school, we filled out a quiz by hand, handed it in with like $2 or something. And then they put it in the Whopper, if you remember War Games, this giant computer, which probably now has less power than this calculator. But back then this is the high tech thing. And, it would tell you like which girls in the high school were like the best match for me, Now we're decades later and here we are with the same feature, but it's AI powered. So, and then they have this real-time recommendation system called Learning Mode, aims to quickly understand what you're looking for and gather feedback to serve you better potential matches. So if you just write hotties, it will send you hotties. There you go. Internal testing of Learning Mode suggests that for women joining Tinder for the first time, Tinder Newbies, it's associated with a higher likelihood of returning to the app within the first week, which of course is a joyous occasion for the shareholders of Tinder, the match group, I guess. And they introduced college mode and double date mode previously, and they have music mode. But apparently they mentioned they're capitalizing the IRL trend, and Rahul and I have talked all about how everything is moving to, or people want to move to IRL dating. So they are testing an events feature in LA that lists local IRL happenings, allowing users to signal their interest in attending. Okay. And they're going to partner with event hosts to offer opportunities to get off the app and into in-person flirting. Okay. There you go. It says, say at a pottery class or trivia night. Who doesn't like flirting over some pottery action? Yeah, like the movie Ghost, or trivia night is also very sexy, as everyone knows. So, okay, there you go. Thank you for that listening. Rahul, how can people find any questions, comments, concerns?
No, that's great. People can find me at Chicago Divorce on Instagram.
Awesome. And people can find me at Rayford Palmer on X and on the artist formerly known as Twitter. On LinkedIn, I'm Rayford Palmer, and Facebook, and you can find our firm STG Divorce Law just by a Google search. We're just a quick Google search away, or Chat GPT, your AI of choice, and find us also. And thanks for listening, folks. We really appreciate it. Like, share, subscribe. Give us a review, please, on your favorite platform, whether it's your podcast platform or on Facebook, YouTube, wherever you are. Please give us a review. We appreciate it. It helps us know that we're doing the right thing and that you enjoy this content. We want to keep this coming for you. We don't charge you anything. That's our gentleman's agreement to you, is that we charge you nothing. In return, we ask for just a review is all we ask for. It just takes 5 seconds. Would you please? Thank you very much. As it relates to the pod, yeah. Thank you very much for listening, everybody. Have a great day.